Chapter 3, Unit 1. Administrative case.
Vụ án hành chính.
Administrative court.
Tòa án hành chính.
Administrative process.
Thủ tục hành chính.
Administration of law.
Áp dụng pháp luật.
Be involved in.
Liên quan đến.
Bylaws.
Quy chế.
Carry out.
Thực hiện.
Checks and balances.
Cân bằng và đối trọng.
Congress.
Quốc hội Mỹ.
Constitution.
Hiến pháp.
Criminal conviction.
Sự kết tội.
Concern.
Liên quan.
Democracy.
Nền dân chủ.
Distinct.
Khác biệt với.
Division of power.
Phân chia quyền lực.
Efficient.
Có hiệu quả.
Efficiency.
Tính hiệu quả.
Economic powers.
Quyền lực kinh tế.
Elect.
Bầu cử.
Entrust.
Giao phó.
Enforcement of law.
Cưỡng chế thực hiện pháp luật.
Executive.
Cơ quan hành pháp.
Exercise.
Thực thi.
Fine.
Phạt tiền.
Fundamental rights.
Các quyền cơ bản.
Law.
Đạo luật.
Lawbreaker.
Người vi phạm pháp luật.
Law court.
Tòa án.
Lawful.
Hợp pháp.
Legislator.
Nhà lập pháp.
Official.
Quan chức.
Senior official.
Quan chức cấp cao.
Oral hearing.
Phiên xét xử.
Montesquieu.
Montesquieu.
Political power.
Quyền lực chính trị.
Reject.
Bác bỏ.
Regulate.
Điều chỉnh.
Res judicata.
Cái được phán định theo luật.
Restrain.
Kiềm chế.
Restrict.
Hạn chế.
Submission.
Sự đệ trình.
Sovereignty.
Chủ quyền.
Statute.
Đạo luật.
Stabilize.
Ổn định.
Supplement.
Bổ sung.
Supranational.
Siêu quốc gia.
To obey law.
Tuân thủ pháp luật.
To enact laws.
Ban hành các đạo luật.
To violate laws.
Vi phạm luật.
To pass bill.
Thông qua dự luật.
To veto bill.
Phủ quyết dự luật.
Chapter 3, Unit 1. Listening 1, United States Government. United States government, the combination of federal, state, and local laws, bodies, and agencies that is responsible for carrying out the operations of the United States. The federal government of the United States is centered in Washington, D.C. The institutions of all the governments emerge from four basic principles. The first principle is representative democracy, which is defined as a system in which the people govern themselves by electing their own leaders. The second principle of the U.S. democracy is representative government. Again, the second principle of the U.S. democracy is representative government. In a representative government, the people delegate their power to elected officials. In turn, these elected officials represent the will of the people and ensure that the government is accountable to its citizens. The third principle of American democracy is the system of checks and balances. The three branches of government, the legislative, the executive, and judicial, restrain and stabilize one another through their separated functions. The legislative branch, represented by Congress, passes bills. The executive can veto bills, thus preventing them from becoming laws. In turn, by 2/3 of vote, Congress can reject the president's veto. The Supreme Court may invalidate acts of Congress by declaring them contrary to the Constitution of the United States. The fourth principle of democracy in the United States is federalism. In the American federal system, the state and the national government divide authority. This division of power helps curb abuses by either the national or the state governments.
Listening 2. The Constitution of the United States. The Constitution of the United States is the supreme law of the United States of America. It is the framework for the organization of the United States government and for the relationship of the federal government with the states, citizens, and all the people within the United States. The first 3 articles of the Constitution establish the 3 branches of the national government: a legislature, the bicameral Congress, an executive branch led by the President, and a judicial branch headed by the Supreme Court. They also specify the powers and duties of each branch. All unenumerated powers are reserved to the prospective states and the people, thereby establishing the federal system of the government. The Constitution was adopted in September 17, 1787, by the Constitutional Convention in Philadelphia, Pennsylvania, and ratified by conventions in each U.S. state in the name of the people. It has been amended 27 times. The first 10 amendments are known as the Bill of Rights. The United States Constitution is the second oldest written constitution still in use by any nation in the world after the 1600 Statutes of San Marino. It holds a central place in the United States law and political culture. The handwritten original document penned by Jacob Shallis is on display at the National Archives and Records Administration in Washington, D.C.
Unit 2. Acquit.
Tha bổng, trắng án.
Accused.
Bị cáo, người bị buộc tội.
Adversarial.
Đối kháng.
Advise.
Tư vấn, khuyên.
Alibis.
Chứng cứ ngoại phạm.
Antitrust.
Cạnh tranh.
Attack.
Tấn công.
Bail.
Bảo lãnh.
Beyond reasonable doubt.
Một cách chắc chắn.
Bribery.
Hối lộ.
Burden of proof.
Trách nhiệm chứng minh.
Circumvention.
Sự dùng mưu kế để lừa.
Concealment.
Sự che giấu.
Counsel.
Luật sư.
Court.
Tòa án.
Corruption.
Tham nhũng.
Counterfeiting.
Sự giả mạo.
Crime.
Tội phạm.
Cross-examination.
Thẩm vấn chéo.
Deceit.
Sự lừa dối.
Deception.
Sự lừa gạt.
Defendant.
Bị đơn.
Defense.
Sự bảo vệ, bào chữa.
Embezzlement.
Biển thủ. Tham ô.
Economic espionage.
Gián điệp kinh tế.
Fraud.
Sự lừa đảo.
Grounds.
Cơ sở, lý do.
Guilty.
Phạm tội.
Illegal.
Bất hợp pháp.
Kickback.
Tiền lại quả.
Manipulation.
Sự lôi kéo, vận động.
Money laundering.
Sửa tiền.
Mugging.
Trấn lột.
Offense.
Sự vi phạm.
Offend.
Vi phạm.
Opponent.
Đối thủ.
Penalty.
Hình phạt.
Guilty plea.
Lời nhận tội.
Plead guilty.
Nhận tội.
Proof.
Chứng cớ.
Prove.
Chứng minh.
Prosecution.
Sự khởi tố. Công tố viên.
Punish.
Trừng phạt.
Punishment.
Hình phạt.
Release.
Thả. Giải phóng.
Sentence.
Án. Định án.
Statutory requirement.
quy định của pháp luật.
Subterfuge.
Thủ đoạn lừa gạt.
Tax evasion.
Trốn thuế.
Temporarily.
Tạm thời.
Trade secret theft.
Ăn cắp bí mật thương mại.
Under arrest.
Bị bắt.
Verdict.
Lời tuyên án.
Whereabouts.
Nơi, ở đâu.
Witness.
Làm chứng, người làm chứng.
Unit 2, Listening 1. White-collar crime tends to refer to crimes committed at a business by a businessman or woman with the growth of technology. The internationalization of the economy has led to more opportunities for white-collar crimes. Such crimes might include embezzlement or fraud. Criminology experts and sociologists posited that people are more likely to commit crimes when they are surrounded by criminal behavior of others. This philosophy relates to punishment of white-collar crime by the U.S. justice system. A white-collar criminal is considered less likely to commit another crime, and punishment may be softer than for crimes involving violence. Today, the definition of white-collar crime may also refer to the socio-economic status of the person committing the crime. A person from the middle or upper classes commits a white-collar crime simply because of his origin. However, if the crime is violent in nature, it still is likely not considered a white-collar crime. Most believe that white-collar crime is a less punishable offense than, for example, a mugging where violence is threatened. However, a white-collar crime like embezzlement, the stealing of company funds, may ultimately harm more people. If funds are irrecoverable, a white-collar criminal might technically steal all the savings of people who depend upon those savings in order to live. When the money cannot be recovered, the white-collar criminal has caused more damage by his actions than the mugger. However, the mugger is likely to receive a stiffer sentence. Since white-collar crime tends to occur among those of higher socioeconomic standing, an advantage is gained. Most people can afford a better lawyer to argue in their defense. Those of lower socioeconomic standing are not likely to be able to afford a private lawyer and must rely on the overworked state defense attorneys. It has been statistically shown that most clients fare better with a private lawyer. White-collar crime falls under the purview of criminal law. The FBI defines it very simply as lying, cheating, and stealing, and it is classified by the Department of Justice as non-violent illegal activities which principally involve traditional notions of deceit, deception, concealment, manipulation, breach of trust, subterfuge, or illegal circumvention. Although there is no definitive universal definition for white-collar crime, it is generally identified as non-violent crimes that public officials and business people commit predominantly for their own personal gain. The subset of criminal law includes a virtual laundry list of offenses, myriad acts of fraud, which is generally defined as the intentional deception of a business or person being chief among them. There are many other crimes, however, that are prominently identified as white-collar crime as well, including the following: public corruption, tax evasion, bribery, counterfeiting, money laundering, embezzlement, kickbacks, environmental law violations, economic espionage, trade secret theft, insider trading on the stock market, illegal pharmaceuticals, antitrust violations, and other forms of dishonest business schemes.
Listening 2. There are 3 categories of criminal offense. Summary offenses, tried without a jury, are minor crimes only triable in the magistrate's court. Indictable offenses are serious crimes, such as murder, which can only be heard in the Crown Court. The formal document containing the alleged offenses, supported by facts, is called the indictment. In case which can be heard in either the magistrate's court or the Crown Court, such as theft or burglary, is triable either way. If the defendant pleads guilty, the magistrate's court can either proceed to sentence or commit to the Crown Court for sentence, where more severe penalties are available. If there is no guilty plea, the court can decide the mode of trial. The person charged may request a trial by jury. If granted, such trials take place in the Crown Court. The English system of justice is adversary. The English system of justice is adversarial, which means that each side collects and presents their own evidence and attacks their opponents by cross-examination. In a criminal trial, the burden of proof is on the prosecution to prove beyond reasonable doubt that the accused is guilty. A person accused or under arrest for an offense may be granted bail and temporarily released. However, bail may be refused. For example, if there are grounds for believing that the accused would fail to appear for trial or commit an offense. In the Crown Court, there may be a preparatory hearing for a complex case before the jury is sworn in. Prior to the trial, there is a statutory requirement for disclosure by the prosecution and defense of material relevant to the case. For example, details on the alibi. People who can provide proof of the accused whereabouts at the time of the crime, or witnesses. People who have seen something relevant to the crime. Once a trial has begun, the defendant may be advised by counsel to change his or her plea to guilty, in expectation of a reduced sentence. If, at the end of the trial, the court's verdict is not guilty, then the defendant is acquitted.
Unit 3. Public International Law.
Công pháp quốc tế,
Private International Law.
tư pháp quốc tế,
Supranational Law.
luật siêu quốc gia,
Compel.
bắt buộc, ép buộc,
Violate.
vi phạm,
Corpus.
phần chính,
Sovereign.
có chủ quyền,
Conflict of laws.
xung đột pháp luật,
Convention.
công ước,
Treaty.
hiệp ước,
Motivate.
thúc đẩy,
Distinguish.
phân biệt, khác biệt,
Binding.
ràng buộc,
Accede.
tham gia, tán thành,
Prolongation.
kéo dài,
Denunciation.
tố cáo,
Ratification.
phê chuẩn,
Appendix.
phụ lục,
Plenipotentiaries.
đại diện toàn quyền,
Void.
vô hiệu,
Revision.
sửa đổi,
Annulment.
bãi bỏ,
Concern.
liên quan,
Arbitration.
trọng tài,
Welfare.
phúc lợi,
Commissioner.
ủy viên,
Solemnly.
long trọng,
Fundamental.
cơ bản,
Correspondence.
tương ứng,
Psychiatric.
tâm thần,
Promotion.
thúc đẩy,
Negotiation.
đàm phán, thương lượng,
Identify.
xác định,
Critical.
quan trọng,
Adequate.
thích hợp,
Presumption.
giả thiết,
Discrimination.
phân biệt đối xử,
Bilateral.
song phương,
Non-governmental.
phi chính phủ,
Multinational.
đa quốc gia,
Intrastate.
nội bộ nhà nước.
Unit 3. Listening 1. Treaties and international conventions are written agreements conducted by two or more sovereign nations or by a nation and an international organization, such as the European Union, establishing their respective rights and obligations in political, economic, or other relations. International treaties may be bilateral or multilateral, depending on the number of parties to the treaty. Multilateral treaties may be open, meaning that other parties may accede to them on the procedures stipulated in the treaty itself, or they may be closed, meaning that non-signatory states may accede to it only with the consent of the parties to the treaty. Reservation to an international treaty stated in the special protocol may be made at the time the treaty is signed, ratified, or when a state accedes to a previously signed international treaty. An international treaty, as a rule, consists of a preamble stating the motives and goals of the treaty, the specific provisions on the nature of the relation the treaty is to regulate, the concluding articles on the treaty's duration and mode of prolongation, notice of denunciation conditions of its coming into force, and its ratification. A treaty may have an appendix that specifies its main provisions and that has the same judicial force as the text of the international treaty itself. Bilateral international treaties are usually drawn up in the languages of the principal contracting parties, multilateral in 1, 2, or more languages. An international treaty concluded by contracting states is a rule subject to ratification or confirmation. Usually the head of state confirms an international treaty after it has been officially signed. The signing of a treaty is sometimes preceded by what is called initialing. The plenipotentiaries affix their signature to every page of the treaty to confirm that the present version is the agreed upon text. An international treaty enters into force after it has been signed if it is so directly stated in the treaty, or after an exchange of ratification, or after the ratifications are deposited with some other state, called the depository, or with the UN. Treaties subject to ratification are discussed and confirmed by the government before they are ratified. In some cases, they are submitted for approval. A treaty may stipulate the exact date when it becomes effective. The contracting parties have the right to select any time for the international treaty to become effective.
Listen to the second part and circle the right word you hear in each number. International treaties are, as a rule, published by the parties that have concluded them in official government publications, in the periodical press, in collections, or in other types of publications. According to the legislation of several countries, published, promulgated, international treaties have the force of law. Members of the UN register the treaties they have concluded with the UN Secretariat, and the registered international treaties are published in the UN collections. An international treaty may terminate upon the expiration of its terms, or because the obligations stipulated in it have been fulfilled, or by mutual consent of the parties to terminate the treaty ahead of time. A treaty may also be terminated through denunciation. In that case, one state informs the other state, or the depository, under conditions agreed upon by the parties in advance, that the treaty between them has been voided. Other ways of terminating an international treaty are revision of the treaty with the consent of the parties to the treaty and an annulment, meaning the unilateral declaration of one state that renounces the treaty. A variety of designations are applied to international treaties, such as treaty, agreement, pact, accord, convention, declaration, communique, protocol, and act. While the contracting parties have the right to choose any designation for a treaty they conclude, in practice, the name of the treaty depends on its content. For instance, a communique usually provides information on the general principles of the government's policies and views on a particular specific issue, and a protocol deals with the settlement of a minor issue within the framework of cooperation of the states concerned. Depending on the agreement of the parties to the treaty, international treaties may either be interpreted by the parties themselves or disputes of interpretation may be submitted to an arbitration commission or to the International Court of Justice to the UN.
Chapter 4, Unit 1. Acceptance.
Sự chấp nhận,
Bind.
ràng buộc,
Binding.
ràng buộc,
Binding obligation.
nghĩa vụ ràng buộc,
Breach.
vi phạm,
Breach of contract.
sự vi phạm hợp đồng,
Breach a contract.
vi phạm hợp đồng,
Breaching party.
bên vi phạm,
Non-breaching party.
bên không vi phạm,
Capacity.
năng lực,
Legal capacity.
năng lực pháp lý,
Mental capacity.
năng lực tâm thần,
Consideration.
sự đảm bảo thực hiện hợp đồng,
Contract.
hợp đồng, giao kết hợp đồng,
Contracting party.
bên giao kết hợp đồng,
Oral contract.
hợp đồng miệng,
Written contract.
hợp đồng viết,
Enter into the contract.
giao kết hợp đồng,
Enforce.
thực thi,
Enforceable.
có thể thực thi,
Legally enforceable agreement.
hợp đồng có thể thực thi về mặt pháp lý,
Exchange.
sự trao đổi,
Hereafter.
dưới đây,
Hereby.
bằng cách này,
Herein.
ở đây,
Hereinafter.
ở dưới đây,
Hereof.
về điều này,
Hereto.
thêm vào đây,
Herewith.
kèm theo đây,
Incompetent.
không có năng lực,
Injunction.
mệnh lệnh của tòa án,
Minor.
trẻ vị thành niên,
Performance.
sự thực hiện,
Perform a contract.
thực hiện hợp đồng,
Promise.
hứa, cam kết,
Requirement.
sự yêu cầu,
Require.
yêu cầu,
Resigned.
hủy bỏ,
Rescission.
sự hủy bỏ,
Terms and conditions.
điều khoản và điều kiện,
Thereafter.
về sau,
Thereby.
bằng cách đó,
Therein.
ở đó,
Thereof.
từ đó,
Thereto.
thêm vào đó,
Therewith.
với điều đó,
Transaction.
giao dịch.
Chapter 4, Unit 1, Listening 1.
So, Mr. Brown, we are happy to offer you £10,000 on the following terms.
Which are?
Well, if we go through the agreement together, I can explain the conditions.
Okay.
The repayment of the loan includes a capital repayment of £10,000 plus annual interest of the appropriate rate.
I see.
And the loan can be repaid over 24 or 36 months.
Right.
At present, interest on the loan will be calculated at 2% above the bank base rate.
Okay.
And we will collect the payment monthly in arrears.
And how will you collect it?
We will debit it directly from your account.
I see.
If you agree to the terms, we can arrange to have the money in your account tomorrow. The first repayment installment will there be due exactly 1 month from tomorrow.
Will the repayment amount be the same each month?
I am afraid we can't guarantee that. The exact amount will depend on the bank base rate. If there is an increase, your monthly repayment will go up. If there is a decrease, it will go down.
And what if I want to repay early?
You can repay the loan early, but there will be a small penalty equal to 1 month interest.
Listening 2. Good morning. I'll begin today's lecture on contract law with the subject of contract formation. More precisely, I will speak about the requirements for formation of contract. There are 2 main requirements: agreement and consideration. There is sometimes said to be a third element, the intention to create legal relations. However, in practice, this third element is not usually a problem, because even if the intention to create legal relations is considered a separate element, it's understood to exist automatically in the vast majority of cases. What does agreement mean in the context of a contract? Agreement refers to a transformation of negotiation into a settled deal. This is the point when negotiations are at an end. The negotiating process is not a part of a contract. However, the law needs to be able to determine when the process of negotiation has ended and the parties have reached an agreement in their commercial arrangement. Traditionally, if you want to answer the question, have the parties reached agreement? You apply the rules of offer and acceptance. When a proper offer has been made by one party and accepted by the other, then there is agreement at the moment of communication of acceptance. This process raises a number of questions. For example, was an offer made at all? Who makes an offer in certain types of transactions? For example, does acceptance have to be communicated? Can you accept by silence? Can you accept by just getting on with the commercial task? And so forth. Let's move on to the subject of consideration. Consideration involves the idea of exchange. It refers to the value, service, information, etc., which is offered to another party in a contract in exchange for that party's agreeing to enter into the contract. Put very simply, what we are talking about here is the price. A contract is not legally binding if each party does not offer at least some consideration to the other party. There are rules about what an exchange is and what parties can exchange in order for it to be good consideration. We will look at these rules next week after we have examined the requirements to offer and acceptance today. There is a relationship between the rules of offer and acceptance on the other hand and the rules of consideration on the other. All this will become clear when we examine consideration in more detail. Unit 2. Agent.
Người đại diện.
Article.
Điều khoản.
Article of Association.
Quy chế của công ty.
Association.
Hiệp hội.
Capital.
Tiền vốn.
Certificate of Incorporation.
Giấy phép thành lập công ty.
Company number.
Số đăng ký của công ty.
Corporation.
Công ty, tập đoàn.
Corporate.
Liên hiệp công ty.
Criminology.
Tội phạm học.
Corruption.
Tham nhũng.
Dividend.
Cổ tức.
Emerge from.
Phát sinh.
Incorporation.
Thành lập công ty.
Issue.
Phát hành.
Formation.
Thành lập.
Fund.
Quỹ, cấp tiền.
Gross.
Tổng.
Joint stock company.
Công ty liên doanh.
Legal requirements.
Yêu cầu của pháp luật.
Memorandum.
Điều lệ của công ty.
Object.
Mục tiêu.
Par value.
Giá trị danh nghĩa.
Partnership.
Công ty hợp danh.
Personality.
Đặc trưng, tính cách.
Profit.
Lợi nhuận.
Proportionate.
Theo tỷ lệ.
Registration.
Đăng ký.
Registered company.
Công ty đã đăng ký.
Share.
Cổ phiếu.
Common share.
Cổ phiếu thông thường.
Preferred share.
Cổ phiếu ưu tiên.
convertible share,
cổ phiếu chuyển đổi,
treasury share,
cổ phiếu quỹ,
statutory books,
sổ sách theo luật định,
proceeds,
tiền thu được,
professional,
chuyên nghiệp,
shelf company,
công ty đã đăng ký,
shareholder,
cổ đông,
trust,
tơ rớt,
vehicle,
phương thức, cách thức,
vicarious,
thay cho ai,
white collar,
thuộc về lao động trí óc,
world trade.
thương mại thế giới.
Unit 2. A capital stock of a corporation is the amount of money, property, or other means authorized by its charter and contributed or agreed to be contributed by the shareholders, which provides the financial basis for the prosecution of the business of the corporation. The term capital, as distinguished from capital stock, indicates the assets of the corporation or that portion of the assets, regardless of their source, which is utilized in the conduct of the corporate business. These shares entitle their owners to a proportionate part of the distributed profits of the corporation to allocate portions of the corporation property upon any distribution thereof. The capital is the property of the corporate entity. All of the shares of stock are the property of the shareholders. Shares of the stock are incorporeal personal property and are in the nature of chose in action, although they do not constitute an indebtedness of the corporation to the shareholders. A share of stock is the actual property of the shareholder, while the certificate of share is merely evidence of the ownership of such shares. The amount and different classes of shares which a corporation may sell or issue depend upon the terms of its charter and of the governing statutes. The basic class of corporate shares is common shares. This is the kind of shares ordinarily and usually issued, without extraordinary rights or privileges, and the class which, in the absence of other classes of shares having superior rights, represents the complete interest in the corporation. Preferred share, as its name implies, is given certain preferences over common share, and dividends on preferred share are usually required to be paid before any distribution of profits to the common share. Dividends on preferred share are usually payable at the fixed rate per share, and they are sometimes made cumulative, so that dividends skipped in one or more years will be made up in succeeding years. Convertible share is that which may be changed from one class of shares to another. Preferred share is frequently made convertible into common share, under specified terms, at the option of the shareholder. Treasury share, as distinguished from unissued share, is corporate share which has been subscribed and paid for, but has thereafter been reacquired by the corporation by purchase or otherwise. Treasury share generally differs from retired share in that the former may be sold, whereas retired share disappears altogether. Corporate shares may have a designated par value stated on the certificate of share, or it may be without par value. The par value, where stated, is usually an arbitrary amount, having little or no relation to the actual value of even the book value of the stock.
2. Corporate crime. In criminology, corporate crime refers to crimes committed either by a corporation, i.e., a business entity having a separate legal personality from the natural persons that manage its activities, or by individuals that may be identified with a corporation or other business entity. See vicarious liability and corporate liability. Note that some forms of corporate corruption may not actually be criminal if they are not specifically illegal under a given system of laws. For example, some jurisdictions allow insider trading. Corporate crime overlaps with white-collar crime, because the majority of individuals who may act as or represent the interests of the corporation are employees or professionals of a higher social class. Organized crime, because criminals can set up corporations either for the purpose of crime or as vehicles for laundering the proceeds of crime. Organized crime has become a branch of big business and is simply the illegal sector of major capital. It has been estimated that by the middle of the 1990s, the gross criminal product of organized crime made it the 20th richest organization in the world, richer than 150 sovereign states. The world's gross criminal product has been estimated at 20% of world trade, and state corporate crime because, in many contexts, the opportunity to commit crime emerges from the relationship between the corporation and the state. Unit 3. Advice.
Lời khuyên,
Assault.
đe dọa hành hung,
Battery.
hành hung,
Care.
sự quan tâm,
Causation.
quan hệ nhân quả,
Conditional fee basis.
cơ sở trả phí có điều kiện,
Contingency fee basis.
cơ sở trả phí có điều kiện,
Compensate.
đền bù,
Compensation.
đền bù,
Damage.
thiệt hại,
Damages.
tiền bồi thường,
Defame.
phỉ báng, bôi nhọ,
Defamation.
phỉ báng, bôi nhọ,
Defamatory.
phỉ báng, bôi nhọ,
Duty of care.
nghĩa vụ quan tâm,
Expert.
chuyên gia,
Fee estimate.
ước tính chi phí,
Halt.
tạm dừng,
Impose.
áp đặt,
Imposition.
sự áp đặt,
Injunction.
mệnh lệnh của tòa án,
Injure.
làm tổn thương,
Injury.
tổn thương, tổn hại,
Leg.
giai đoạn,
Liability.
trách nhiệm pháp lý,
Strict liability.
trách nhiệm pháp lý vô điều kiện,
Litigation.
kiện tụng, tranh tụng,
Link.
mối liên hệ,
Medical records.
hồ sơ bệnh án,
Disability.
tàn tật,
Negligence.
sự bất cẩn,
Negligent.
bất cẩn,
Nuisance.
sự phiền toái khó chịu,
Impartial.
vô tư,
Outcome.
kết quả,
Patient.
bệnh nhân,
Practitioner.
bác sĩ,
Process.
quy trình,
Proximate.
trực tiếp,
Pursue.
theo đuổi,
Reputable.
có danh tiếng,
Reasonable person.
người bình thường,
Remedy.
phương thức,
Stay.
tạm dừng,
Suffer.
chịu đựng,
Treatment.
sự chữa trị,
Trespass.
sự xâm phạm,
Tort.
lỗi,
Tortfeasor.
người gây lỗi,
Unbiased.
vô tư,
Wrong.
hành vi sai, lỗi.
Unit 3. Listening 1. Civil Procedures. Part 1. Listen to a lecture on civil procedure in England and Wales.
Most claims are initiated by the use of a claim form, which functions as a summons. The claim form can be used for different types of claim. For example, for specified or unspecified monetary sums, or for the claimant to ask the court to make an order. Once a claim has been issued, a copy is served on, that is, delivered to, the defendant with a response pack inviting them to either admit the claim, using a form of admission, or to defend it, using a form of defense. The response pack also contains an acknowledgement of service form to confirm receipt of the claim, and a counterclaim form for the defendant to use it if they wish to claim against the claimant. A defendant must respond within 14 days of service of the particulars of the claim. If the defendant does not respond, judgment may be given in favor of the claimant. The defendant may be able to get a time extension for filing a reply on defense by using the part of the Acknowledgement of Service form which states an intention to defend the claim.
Part 2. Cases are allocated to a regime or track by a procedural judge according to their monetary value. Claims of £5,000 or less are allocated to a small claims track, while claims up to £15,000 are allocated to a fast track. More complex claims track with a greater value are allocated to a multi-track regime. Fast track directions might include disclosure, where the claimant tells the defense of any relevant documents in their possession. This is followed by inspection, initiated by a written request by the claimant to look at relevant documents held by the defense, and an exchange of witness statements. The multi-track regime is intended to be flexible and does not have a standard procedure. In all regimes, parties are encouraged to settle their differences and for this purpose a stay in proceedings, that is, a temporary halt may be agreed. Case management conferences are often conducted by telephone and give parties the opportunity to review the process and make decisions. If a defendant is ordered to pay a judge and fails to do so, the claimant can enforce the judgment in the magistrate's court. Listening to clinical negligence practice. David Jones specializes in clinical negligence at a regional law firm, Jamison's. Katrina Mack Leland is a third-year law student who is undertaking a summer work placement in a litigation department at Jamison's. David is describing his practice to Katrina.
At Jamison's, claimants instruct us. That is to say, individuals come to us to get an idea of whether they have a potential claim, to find out how strong their claim is and what the process will involve. Depending on that advice, they may then instruct us to pursue the claim on their behalf. The likely amount of damages has to be enough to cover the cost of investigating a claim.
How do individuals finance this legal work? Isn't it very expensive?
Yes, it can be. I'm always very careful to give clients a fee estimate at the onset. Initially, this will just be for the cost of exploring the claim. This will involve obtaining the client's medical records from the relevant general medical practice or hospital. I usually go through these before instructing an independent expert to prepare a report. The department keeps a register of experts which we'll use for an impartial, that is, unbiased opinion. Some clients may have legal expenses, insurance, or may qualify for public funding, and others may have to fund themselves. In those cases, we usually agree a payment schedule with the client. If we do pursue the claim, this is usually on a conditional fee basis. That is, no win, no fee. So there is an element of risk involved.
What does the success of a claim depend on?
Well, obviously the basis is that the claimant has sought medical advice or treatment and believes that as a result of that advice or treatment, their health has suffered. We have to show that there is a causal link between the two things, that there is causation. The second essential leg is that there has been an element of negligence. Sometimes this involves extremely complicated evidence. Basically, we need to demonstrate that the course of action or advice given by the doctor in the case in point would not be that advised by a similarly experienced and reputable body of practitioners. As you can imagine, the role of the expert in all of this is extremely important. We rely upon them to explain how the action of the defendant has adversely affected the outcome for the patient. The other extremely important point is that the claimant must bring the claim within the limitation period. This is usually within 3 years of the event. although this may be extended if the case involves a child or the claimant has a mental disability. Unit 3. Arbiter.
Người có quyền quyết định làm.
Ambiguous.
Mơ hồ, khó hiểu.
Accessibility.
Sử dụng được.
Assert.
Khẳng định.
Bill.
Dự luật.
Contradictory.
Mâu thuẫn, trái ngược.
Comprehensibility.
Có thể hiểu được đầy đủ.
Debate.
Thảo luận, tranh luận.
Democracy.
Chế độ dân chủ.
Enshrine.
Lưu giữ.
Gigantic.
Cách xù.
Incorporate.
Kết hợp.
Lawmaker.
Ngành lập pháp, người làm luật.
Liberty.
Quyền tự do.
Medieval.
Thuộc về thời Trung Cổ.
Precedent.
Án lệ.
Requirement.
Yêu cầu, đòi hỏi.
Submit.
Đệ trình.